Thank you. Good morning. Welcome to the 5th District Court of Appeal, our oral argument session for this morning. Before we get started, let me introduce the judges on our panel. Again, I'm Judge Boatwright. To my right is Judge Brian Lambert. And to my left, we have an associate judge from the 4th Judicial Circuit, Meredith Carbula, and we are privileged to have her with us today and this week. We have 3 cases on the docket this morning. Each side will have 20 minutes to argue their case. Appellant is allowed time for rebuttal argument, so when you come forward, please let us know how much time you'd like for rebuttal. The first case on the docket is case number 24-2592, Cross versus Dooley. So, Mr. Grassley, you ready?
Good morning. May it please the court.
Sorry about that.
For the second time in almost 40 years of practice, I have to start with a little bit of housekeeping, if I could approach and hand you some copies of cases that were decided yesterday at 3 o'clock by the 3rd District that are relocation cases that have to do with the set. There's 2 pages of one. The only relevance that these cases have is it reaffirms the standard of review.
How much time would you like for
I'm
rebuttal?
sorry, 5 minutes is my aspirational goal. Thank you, Judge.
Did you give a copy of this to opposing counsel?
As soon as I got it. And again, it's not particularly relevant. It is not controverted here that despite what the knowledgeable appellee says, that I'm trying to ask this court to reweigh the evidence and substitute its judgment for that of the trial court. That's not the case. The case here has to do with the trial court's misapplication of the statute and making findings that are not supported by evidence.
So how did the trial court judge misapply the statute?
The essence of the order that's under review is that it's not convenient or practical for my client to relocate because it would cause the father, who does not exercise all of his time sharing currently, it would require him to miss a Friday.
It's a best interest test, correct?
The best interest is the guiding principle. And
so did the trial court judge not make a best interest determination?
he made one that is contrary to the actual evidence and is not supported by evidence.
So he at least legally followed the law. Maybe you say the facts aren't. You disagree with how he applied the facts.
I disagree with both his interpretation of what the statute requires and let me see, I've got it here. The statute says a presumption in favor or against a request to relocate with a child does not arise if a parent or other person seeks to relocate and the move will materially affect the current schedule of contact, access, and time sharing with a non-relocating parent or other person. What that means is inherent in every relocation case, you're going to have some different type of time sharing arrangements. Decision out of the third that we talk about, the Vacqui, I think is how it's pronounced, allowed a relocation by the mother with the child from Dade County to California because of a military reassignment of her current husband. And they do go through the long discussion about what is going to be different. And they recognize that the only change in the relationship is going to be the amount of time sharing that the father in Miami is going to lose. And they still affirm the relocation. My point is that what this judge did was he decided that the inconvenience to the father of having to drive and miss 2 Friday night dinners with his younger family, his current family, outweighed my client's once-in-a-lifetime opportunity to become employed in her field and become a practicing clinical psychologist. The focus on the inconvenience to the non-relocating parent is contrary to what the presumption, the lack of a presumption in the relocation statute provides. The most important finding here that is completely without an evidentiary basis is the court's finding that, quote, my client could apply for and obtain a job anywhere, which made her relocation unnecessary. That is utterly wrong, and it has no factual basis. That was a suggested question by opposing counsel at trial, and my client was adamant and clear and unequivocal. She cannot, with an undergraduate degree in psychology, become any kind of counselor in St. Augustine or anywhere else. She has to have an advanced degree, and she is trying. She's an Air Force veteran. She worked as a manager of an Airbnb and then did a 4-year undergraduate program at the University of North Florida in Jacksonville in 3 years and got accepted to one of the few positions available in Tampa. The Botterbush case, which we talk about, was an officer, Botterbush, got an opportunity to become, instead of I think a deputy sheriff in St. Lucie County, needed to move to Tampa because she got a job with the a federal agency. I can't remember. It was
Well, I mean, didn't this judge kind of acknowledge this was a close call?
They're all close calls in these cases, Judge. We recognize that relocation cases are a torture to all of us, particularly those who are actively involved with their child's life. Those are the cases that are the really hard ones. This one is not. This father.
So what's the standard here? What's the standard of review for us?
Standard of review is whether there has been a proper application of the statutory criteria, which is a de novo review, and then the other one is if there is competent substantial evidence to support the judge's findings. This is not the only, the one that says that, well, she doesn't have to move. She does have to move unless she wants to have no economic opportunity in her chosen profession.
Counsel, wasn't there evidence that there was a program available in Melbourne that she could have applied for, but she declined to take the GRE?
No, ma'am. Well, part of that's accurate. She could not take the GRE because she was a full-time student and didn't have the ability to do that. The question is not whether there were other programs, because that was a 2-hour drive for her every day if she was going to stay in St. Augustine. This is much less onerous on both parties. The important thing is she has been accepted at a top-notch place to become a clinical psychologist, practicing psychologist. That opportunity is not available to her anywhere else at this point in time. And the fact that opposing counsel said, well, you could have picked a different school, so what? I mean, that's not true, but so what? It was not practical, and she couldn't take the GRE. She was trying desperately to work this out, and the evidence showed that the father refuses to communicate with her.
Are you telling us as a matter of law the relocation should have been granted?
I'm sorry, say
Are you
that.
telling us as a matter of law the relocation should have been granted?
As a
That's what I'm hearing, so tell me otherwise.
Well, what is the remedy here for saying, well, this is going to inconvenience the father and it's not practical, which neither one of those are factually based. The remedy is to send it back. Would I like for you to send it back and say you should grant relocation? Yes.
What do we send it back to do then?
To eliminate any findings that are not supported by the evidence. This thing that this child won't thrive and won't be able to be spontaneous with her half-siblings if she has to do twice a month meet in Ocala and do time sharing has utterly no basis. She's going to have as much time sharing and as much time with her father and her siblings if relocation is granted. So the judge has made all these findings, and I'm going to assume, I don't know this for sure, but this looks like it was a proposed order drafted by the Father's Council because it has things in it that just have no evidentiary basis. The fundamental legal problem here, Judge, is this idea that somehow this is going to change the structure of time sharing and require the father to do something that he's proven he doesn't want to do, which is, I don't want to inconvenience myself by missing 2 Friday night dinners with my young family in order to accommodate this. This is a once-in-a-lifetime opportunity.
So I hear what you, look, there's no doubt this is probably a good move for the mother, but is that really the standard? I mean, what I hear you arguing is this is the best interest for her.
Absolutely, but it's also the best interest of the child.
And how is that?
I'm going to quote to you real quickly from the Orta case that I cited in the reply brief and the initial brief. Quote, critically important for a relocation analysis is which parent is the one who has consistently cared for the child for most of his or her life, as children are entitled to stability in their lives and routine. My client has been almost the sole source.
What year is that case that you just cited from?
2011.
Okay.
And I don't know how that would change.
So the appellee cites the cases, and one from our court, which says the focus, I mean, you would agree, the focus is not on the best interests of the mother, it's the best interest of the child. You would
That's
agree.
correct. And
So
who
how
has-
is this, it seemed like the whole focus below, and even what you're arguing here, seems to be what is in the best interest of the mother. So how is this in the best interest of the child?
The reason I'm talking so much about the mother is because the trial court fundamentally misunderstood what's inherent in a relocation analysis under the statute and made up facts that do not have evidentiary support and are contrary to common sense. I mean, I had a daughter that I put on a school bus at 5:30 in the morning for 2 years in high school. So what? This child rode 2-hour round trips 3 days a week with her mother for 3 years while she got her undergrad degree. The child testified.
Talking about your child or this case?
No, my child is on the school bus at 5:30. I
Okay,
mean,
all right.
so what? The judge is like, well, this is impractical. Well, I have a hard time with that, just because it makes no sense. Kids have to get up and go to school in the dark all the time. The child testified that she's got these 8 and 10-year younger half-siblings, that she doesn't have much of any time alone with her father ever, and she's looking forward to spending an hour and a half in the car with him twice a month to have some one-on-one time. There was nothing to suggest that she wasn't up for this or that it is somehow going to negatively impact her. The mother presented...
The trial court found she was a little bit naive in saying these things, correct? So that's a finding that he made. Why is he wrong?
And he's entitled to do that as the trial judge, isn't he?
Okay, I am not...
Yes, right?
Yes,
Okay,
yes, of course he is.
Okay.
But is that something that makes common sense, given this child's experiences? Is that something that takes away from the fact that the only evidence about what was awaiting for this child in Tampa was an expanded curriculum for both music, which they all admitted she loves and is talented at, and she loves to do design, costume design, and arts. And these are available at the school that she's going to live right next door to, in a neighborhood that has kids, which she doesn't have at either parent's house in St. Augustine, and that the kids that are in her neighborhood are going to be her classmates. This is...
They live in St. Augustine Shores right now in St. Augustine. Are you saying there's no, are you saying there's no kids in that neighborhood? It's a pretty big neighborhood.
No, what the testimony was, and I'm sorry, I know Jacksonville very well, St. Augustine not so well. Whatever is going on in St. Augustine Shores, the testimony was there were no kids in her neighborhood that she went to school with, that she could, go outside and play with. That was the testimony. The bottom line, judges, your honors, is these facts show that the only evidence that the judge had in front of him about what the impact on this child would be is, number one, and crucial, is that her mom, my client, is the only sole source of stability and support that she's ever had. The dad does absolutely nothing, he has no involvement whatsoever in her school activities or work.
Counsel, but wasn't the testimony that if relocation was denied, that mom would not move? So it seems to me that the bond the child has with her mom is going to remain. Nothing is going to interfere with that, because the mother is testified, I believe, that she was not going to relocate if relocation was denied. So how does the order denying relocation affect the child's relationship with the mom in any way?
The mom is now going to be stuck in an economic dead end instead of her child being able to watch her mother get her psychology doctorate degree and have an experience in Tampa that she cannot have in St. Augustine. What you've just posed, Your Honor, is a parent who wants to relocate because of a compelling reason. And I think we would all agree this is a compelling reason for her. This is not some made up, oh, I can make $10 more an hour or something. This is a life-changing decision for my client. The Hobson's choice is what you've just given me, which is I can either take my child who has been with me at the hip from day one and who I'm always responsible for, and I always make sure she's got what she needs and she gets help with her schoolwork or whatever project she's working on, and make a better life for myself and my daughter, or I get to stay stuck because of the inconvenience to the father. That cannot be a justifiable conclusion based on these record facts or actually based on the lack of record facts and the speculation by the judge and assertions which utterly are without evidentiary basis.
So when this judge went through all the 11 factors, which it would seem from a baseline level, that's what we want all trial judges to do when they're addressing this, you're saying that this judge, under each of these various factors where he writes whatever he writes in his analysis of whether to grant the petition or not, he just made up facts?
Yes.
He
some
made
of
up
them.
facts. There's
Some of them.
nothing in the record about any, he just decided to, I mean, because if I understood, he, at the conclusion of the testimony, he took about a 45-minute break and came back and explained what he was ruling. So it's not a scenario where the case is over and then 11 months later I write something and then we have the discussions on appeal about, well, you don't remember anything that was talked about.
And I understand, but the other side of what you're telling me is if a judge, without evidence or misunderstanding the evidence, that no rational person could have sat in this trial and come away and saying, she got economic opportunities everywhere, she doesn't, relocation's not necessary. Well, once he's made that error, which is utterly without any factual basis and is directly contrary to the only evidence, which was my client's testimony about this, once he made that error, that permeates this entire analysis. And
So if he didn't make, you're saying if he didn't make that comment either orally or in the written order, that he clearly would have granted the motion or the petition?
I think this judge was convinced that having to drive this child was just too inconvenient for the father. That's what comes across to me. I mean, I'm not going to speculate. I'm looking at what he said. And what he said is factually not existent in the evidence.
You're in your rebuttal time.
I am, and I hope to use some of it. Thank you, Judge.
May it please the court. Counsel? My name is Clyde Taylor. I represent the father, Jason Dooley.
Were you the trial attorney?
Excuse me?
Were you the trial attorney?
Was not.
Okay, go ahead.
Our position is pretty simple, and that is that the judge made the decision that it was not in the best interest of the child to relocate with the mother. It was based on the evidence that was presented, and the court went through all the factors in the relocation statute.
What is the standard here? We discussed that a minute. What is the standard here for the trial court
I think
judge?
truly the standard of review here is abuse of discretion, because there is a correct application of the law. I struggle to see appellant's argument that this is a misapplication of the law. He clearly went through all the factors in the order.
And he cited the factors correctly, and he filled in the blanks, so to speak, after each factor based on the evidence that the judge, heard and how he interpreted it?
He did, Judge. And I mean, there are a couple of cases that say just because you do that's not enough, that I believe the appellant cites, but those cases are extreme. They just would not add up. The facts would be recited that would be very favorable to a relocation or the otherwise, and then there's a complete reversal of the decision in the written order. So it's not just the fact that he cited the factors, it's the fact that he also...
Sounds like your opponent is saying this is extreme, that, hey, the mother, Miss Cross, had this ability, once-in-a-lifetime opportunity to advance her career, and the child's going to benefit by having a mother who is goal-oriented and going to have a professional, be a psychologist, I guess is what she wants to be. And the daughter's clearly going to benefit by that, and it's a good school system that she's going to go to. And so the argument seems to be, well, what more could she have done to convince a judge to relocate? And if these facts aren't sufficient, then there is no facts that are sufficient. It seems to be the underlying theme.
Well,
And I don't want to put words in his mouth, but that seems...
I think that is what their argument is. The problem is that what needs to do more is to show the judge, to demonstrate that this is actually going to benefit the child.
How would one do that?
Well,
I mean, because the child's going to an unknown. I mean, it's going from one coast to the other. I mean, we have other cases where they go from Florida to Colorado or something like that.
well, I think there needs to be some sort of comparison to start. there are plenty of cases where they evaluate the educational system. There's great educational opportunities. But then sometimes appellate court said, well, there's also good educational opportunities where the child is. So inevitably, there's going to be some sort of comparison to show that this is actually going to be in the best interest. It's going to be better. Or
St. Johns County have good school system?
they do. There's, the records.
Was there evidence in the record, or as opposed
Yeah, it's
to?
pretty fuzzy, but I do believe at some point it was put out there as a general matter that they're a very good school system. There were some evidence that was tried to be introduced from the mother that the Hillsborough and the school that she had was also a good system. But the point is, they really relied with educational opportunities. They narrowed in and had tunnel vision on this desire to play cello. That was the main selling point from an educational standpoint.
Child ever played cello before?
Child had never played cello before.
Did she own a cello? Do you
Did not own a
From the
cello.
record? Okay.
So that would be another good example of, well, if that were really the case, maybe she was recognized as a extremely talented cellist and this was going to be a career for her. If there was some special opportunity in Tampa, then maybe that's going to be better for the child.
Counsel, what do you say to your opponent's assertion that there was no competent substantial evidence in the record to support that the mother could gain meaningful employment in St. Augustine?
There is plenty of evidence that she graduated with a psychology degree. And though there was not any showing by her, which is important because it was her burden, to show that there were no jobs in St. Augustine. There was no evidence of that. The judge does say that there's no, that he contends that she could find some work in the area. And I think that's just a fair, common sense conclusion.
Well, okay, she's walking around, she has common sense, she's a smart but she can't be a psychologist. Walking out with a bachelor's degree of psychology, you're not going to be a psychologist.
That was the testimony, yes.
But that's accurate, isn't it?
I don't know, but I'll rely on, that's what it says, is that you can't be a psychologist without, I guess, some sort of graduate degree. There was some talk about a master's program, and why didn't she take the master's program?
So there was record evidence of a master's program being able to get a job that way, correct?
In the
Which she
area,
could have
yes.
gone to school at least closer.
Yes, and it was very clear that she thought that this was the best program, what she wanted to do, which is perfectly within her right, obviously. But the flaw in their case is, how does that translate into the best interest of the child? And that's where they come up short.
Let me ask you, the judge did make, when he was going through the factors, he did find some of the factors favored the mother for relocation. Is any one factor more important than the other factor?
No. If that were the case, then I think the statute would say so. And that is another flaw in the appellant's argument, is that this is going to be inconvenient for the father. And while there is never a mention anywhere in the order that this is just too inconvenient, as it's characterized, it certainly was a fact that I think the judge took into consideration when evaluating the fact.
Is that wrong to take into consideration the inconvenience to the non-relocating party?
Absolutely not. Not when it would be detrimental to the child's interest, which is how he tied that particularly to education. Judge is particularly concerned about, we have a child that we know has special needs, has a 504 plan, has ADD, is not a morning person, and now, and she had, I think, C's and D's.
I mean, wouldn't that favor the relocation, that she's not doing well where she is in the St. John's school system, for whatever reason, and that, I will take her to Hillsborough and we'll start a new programs and cello programs that the child apparently expressed interest in doing. And I mean, it's one thing to say, I have a child who's getting straight A's and we're going to take her out of that environment, she's thriving educationally, and move across the state and hope for the best. That, perhaps she will because she's a good student, but why upset the apple cart? But that's not your facts that are favorable to your side today.
That, in theory, Judge, I think you're correct. However, that was not what the evidence was. They never tried to say that the school is bad here, she's struggling because of her school, because of her grades.
But she's not doing well, though. school. I'm not criticizing the school. For whatever reason, in the environment she was in St. John's, her school grades reflect difficulty with her achieving success at school.
True. So that was an opportunity, if the mother wanted, to try to put some evidence that she would actually do better. It would be in her best interest to go to
How
the
would
school.
she present evidence that she's going to do better in Hillsborough when the child's not in Hillsborough yet?
You know, that I think would be
That's
difficult.
his point. I mean, that's part of the point on the other side, saying, you know, that the child's doing not well in school, so and she's interested in moving, she expressed a desire to move, she wants to do the cello, play the cello in the program, and, you know, it's an unattainable evidentiary burden to say, well, you don't know how well she's going to do in Hillsborough. So, well, yeah, I know, because I can't relocate. The statute says I can't relocate, basically, until I get permission. So, I mean, it would seem to me that if I'm trying to relocate, I'd say, well, look, here's the problem she's having in school right now. But I'm not saying this is happening, she's being bullied, she's doing poorly in school, et cetera. If I move her away to a brand new environment, we can start afresh, that's logical progression. That might be her best interest to move away from where she's having educational difficulties, isn't it?
There is some
There's
logic.
something illogical about what I just said. Now, not that I haven't been accused about being illogical at times, but
Nothing illogical, but it's just as
apply the
logical.
text of the statute, I think that's what happened.
It's just as logical that there'd be no way to tell whether she'd do better and that she could do worse, especially given the fact that she has ADD and the travel component clearly was important to the judge. We're now going to make this child get up earlier, be tired, and have to travel every other weekend, where right now she doesn't have that. She's
Well, I
already
mean, can't
struggling.
they just figure out, maybe don't drive Monday morning, drive Sunday night or something like that, and refigure the plan, and more time in the summer or something like that? I mean, because, I mean, you know, it's a valid, you know, and I hate to hearken back to my days of yesterday, but 30 years ago, I was involved in a relocation case as a lawyer in front of here, where the person was granted permission, my client, to go to Colorado. Actually, she wasn't granted permission, the DCA reversed in my favor, because she was going to be going to Colorado, moving to Colorado with a kid. And they said, well, you know, these things happen, and you got to refigure. You know, it's not going to be every other weekend and Wednesday evenings or something. But they, you know, our predecessors on the panel here said, you know, those are things that happen in relocation things. So you can always refigure. You're going to have to refigure the amount of time. You know, it's not going to be every other weekend, but, you know, this theory of, well, it's going to be Monday morning and that's not a good thing to, you know, get up at 5 and start school at 8 and drive across the state. Okay, well then, figure out something else. Leave 6 o'clock on, you know, Sunday evening.
The problem is that's not what she was asking for. She had a very specific schedule. This is how she saw that it would work.
Well, she has to present a schedule as part of the statute, doesn't it, as part of the plan?
Well, sure, there needs to be some sort of modification of the time
Well,
sheet.
but I mean, the statute says you get, and here's my proposal, Judge, you just can't say, I want to relocate and let's figure it out.
Even if you eliminated those problems with the travel and the inconvenience and the detriment to the child, that's just one of many factors that the court has to consider. And, of course, as I'm sure you're aware, that there needs to be some deference before to do the trial court, who is there to sit there and evaluate the evidence. And
Well, I mean, again, with hearkening back to my 30-year-old case, and the reason I was asking about that predates this statute. This is the 1995 case. But, I mean, you know, the judge made findings fairly, you know, adverse to my client relocating, and the appellate court says, you know, at some point, your relocations are granted, and just that it's going to interfere with the non-relocating person's ability to spend the time they already are having, that's not the end all, that's not the tail that wags the dog. I don't think they use that verbiage, but that was part of the analysis in the case, and the evidence was that the move was going to greatly benefit the mother, and by definition, the child. Now, I'm not saying that's right, that's just what happened 30 years ago, but I'm trying to, you know, anecdotally say, this is why relocations, you know, you don't know, it's the unknown you're going to, and you put the best evidence you can as to the relocation, but, you know, until you actually relocate and see how it goes, the trial judge has to base the evidence on what he or she hears, so.
Well, I think that's exactly what the court did below. Heard the evidence, went through all the factors. It was a hearing that was spread out over the course of 3 days. gave the mother ample opportunity to try to show how this was the best interest of the child, and she came up short. That's what the court found, was not convinced that this was actually going to be in the best interest of the child. One of the other factors that certainly seemed to be important to the judge was the fact that she had significant family ties in St. Augustine. Not only was her father's family there, the mother's grandmother was there. There was really nobody in Tampa.
Yeah, but didn't Grandma say that she was going to move to Tampa if the relocation was granted?
If you look at exactly what she said that she was going to try. She had a job that she would need to find a new job. She also mentioned that her husband needed to retire. There was no specificity. She would then need to sell her home in St. Augustine and then find something else in
They
Tampa.
actually had a minor child, too.
They had their
That child was going to be uprooted as a part of this.
ward, right? Completely not mentioned at all. What's going to happen to this ward at 9 years old, I believe. So the point is, there's speculation or a lot of assumptions that could even happen. But yes, she did express a willingness to move. Speculation is kind of one of these things that permeates throughout her case to try to say this was in her best interest. Yes, she got into a program. She would have to succeed in it. She was not going to get paid. This was not going to financially benefit the child immediately. And it really was not going to financially benefit the child until the child became an adult.
Well, I mean, at the end of the day, isn't this the judge weighed all the factors, set forth in his order, went through the 11 statutory factors, some favor relocation, some didn't favor relocation. He then made the decision based upon the verbiage of the statute, and I guess at the end of the day, if the judge had granted the relocation, you would lose here today if you were arguing otherwise?
Well,
Wouldn't you?
Yes, on a
There you go.
temporary basis. The other thing is we have to
Well, I'm not saying that's not a helpful response that you're giving, but go ahead.
Well, what I'm hearing from you is that if the judge considered all the evidence
Right.
and he based the decision on the factors required by statute and he ruled against us, then yes, because that's what the
And if you were up here appealing, we'd be looking at you saying, isn't this an abuse of discretion? There certainly was competent, substantial evidence that would support not relocating, but there is competent support, and therefore, the fact that there's evidence that helps you, that's not the end-all, be-all, and it's an abuse of discretion, which is a difficult standard under Canacaris. So you would lose if the relocation had been granted and you were sitting over there, I guess. I don't know why the appellants all sit over there for some reason. But
The only reason I would say we could lose is because close calls are not going to be retried by this court. And if it was a close call and the
Right.
judge followed the law, and I wouldn't even concede this is a close call, because there is nothing
well, it's a
apparent.
closer call in the sense that he didn't say, here's the 11 factors, every one of them do not favor relocation.
I mean, the judge said it was a close
Sure.
call.
Judge said it was close, and he's found factors that supported relocation. So it is a closer call. I mean, I don't know how you, I don't think that's a bad thing for you to concede. I know lawyers don't like to concede anything because you think we're going to run with it and put,
Is there some issue with this being temporary? Is there something else filed? Does she have another opportunity to argue this? I wasn't quite sure when you said this was a temporary relocation. Has
This
she
is a
filed
motion-
a final, has she filed for like some type of final relocation or no?
She would be entitled to have a final hearing on this. This is a temporary motion. And I think the statutory framework is designed to have something that happens pretty quickly so people can make decisions. And to expedite, there are some frameworks.
statute says you need to fast forward it when you're a
Do
trial
it
judge.
quickly.
Yeah.
And so even if you affirm this order, as far as I know, procedurally, there still can be a final hearing on the issue of relocation. That's what the statute says. But I also think what's significant about that is that, typically in temporary hearings in family law cases, there's going to be even more discretion for the judge. So that's really the issue here is, did the judge abuse his discretion or not? And the answer, clearly in our opinion, is no. he not only expressed his opinion, his rationale immediately after taking his time to think about it.
So you don't think this is a de novo review like your opponent is saying? You're saying the statute, it says what it says, the judge read the statute, he cited the statute in the order, and then he applied the facts as he weighed them and came up with a ruling, and it's just a matter of, was there competent, substantial evidence to support that? And if so, was it an abuse of discretion to do what he did?
I do think it's truly an abuse of discretion case, because to make this an interpretation of the law, you have to rewrite the statute. I understand, I think, what the argument is, and certainly if this were a misinterpretation of the law, it'd be de novo, but that's not what happened here. I think the judge...
You don't think we can rewrite the statute?
No, not at all. Not that I don't
Say
think...
that for our Federalist presider over here. Likes to rewrite statutes on a daily basis, I think. I'm just kidding, whoever's up in the JQC land.
Unless there are any further questions, I think all the issues have been fleshed out.
Okay, I don't see any. Thank you.
I thank you for your time, and we ask that you affirm the order on appeal. Thanks.
Okay, sir, you have 4 minutes and 30 seconds. for
Thank you, Your
rebuttal.
Honor. Number one, my assertion that the judge found that this was inconvenient to the to the father, that's my word. What he used was, quote, impractical. I think those are the same things under the facts of this case. The whole thing about a cello is a red herring. The child, she had a list about this many instruments that she played. She's obviously a very talented, can pick up and play anything. I've known a few people like that. It's amazing. She wanted to learn how to play the cello. The only testimony about this was that there was not a program in her St. Johns County school that allowed that, or provided that. But that was not all. The mother put on testimony about what all the school in Hillsborough County would provide for her daughter, which were much more expansive than what's in St. Johns County. That's the only evidence. The only other thing was the constant questions by father's counsel that were based on non-evidentiary factors, such as you could have gone to FIT or FTI, whatever the other school was. There was, and if I am wrong, I stand corrected, but I don't remember a single utterance of anything about this child not being a morning person. This child testified to the judge.
I thought her father testified that she was not a morning person.
Okay, well, I stand corrected on that. She testified that when she was, for the last 3 years while her mother was going to school, she got up at 6 o'clock every morning and fed the dog and got some cereal and got herself ready for school. So she obviously has been functioning. Her learning issue is she just needs help staying on track. The only evidence was the father had no role whatsoever in helping her develop lists that the mother has to keep her doing chores and staying focused, which is why she has a 504 plan. He has absolutely no input, no involvement with the child's education. Only the mother does. The last issue that I need to make sure I've mentioned here is the relocation statute says that one of the things the judge must consider in a temporary order is whether a permanent relocation would likely be granted. So for all practical purposes, this judge has slammed the door. Yes, technically she can go back and ask for a final hearing and do this again.
But what if the evidence has changed from this hearing to that the child's doing worse now at the school or what have you, and that this may be
Nothing can stop that from happening, but talk about speculation. We do not know that. What we know...
The statute permits it, though.
Yes,
and so
absolutely.
we apply the language.
No question. The findings that this is going to impact the relationship with the half-siblings is no evidence to support that.
What about the finding that there will be no economic benefit to the child while she's a minor if this relocation is granted because the mother won't get her PhD until the child's basically 18?
I submit that that's a complete red herring. The mother has borrowed money to be able to do this. She's got student loans. She is the one who, for the last 3 years, with just the modest child support that the father pays, everything she's ever asked him to help with for extracurricular anything, anything, the answer has always been no. He did not deny that. He never wants to talk to her about anything to do with this child. He is not involved in the child's activities or anything else. The financial issue is my client has managed to support and provide for everything this child has needed on her own, other than the minimum child support, for the last 3 years, and continues to do so it will continue to do so while she goes to get her doctorate degree. The finding that the father opposes relocation because he wants to preserve his relationship with the child, he's getting exactly the same time sharing. It's in different configurations, which is inherent in the relocation itself, and that's what I have submitted as a de novo review of a misapplication of the statute. Because this judge, when you read through the factors, including the ones that have no evidentiary basis, it all appears that, well, this is going to change his time sharing, and that's not allowed. Thank you so much for having an argument for us. Thank you.
Okay, thank you, gentlemen. Well-argued case. We do have a case at 10 o'clock, so we're going to take a brief recess until 10 o'clock.